5 seconds to go. Start. We have also taken note of the submissions that, according to the appellant, he had already been exonerated of all charges after detailed departmental proceedings, and such a fact did not appear before the High Court for want of notice to him. For the present purpose, suffice it to observe that even if the appellant had been exonerated in the departmental proceedings, such a fact, by itself, may not be conclusive of criminal investigation, and for this fact alone, the High Court could not have ignored all other features of the case and the material factors that had surfaced before it. Para. At this juncture, and in the last segment of this discussion, it may also be observed that we have taken note of another peculiar feature connected to this case, that apart from the subject matter of the present appeal, being barred PS case number 115 of 2012, there had also been another matter, being Bikram PS case number 129 of 2012 against the respondent number 3, as also the present appellant, pertaining to similar allegations of misappropriation of goods. As per the submissions made on behalf of the state, in the said Bikram PS case number 129 of 2012, instituted for offences under sections 409, 420, 468, 471 and 474 IPC, after finding prima facie case against the present appellant, prosecution sanction has also been obtained, and after the order passed by the High Court, the investigation in the present case was also carried out along with the aforesaid Bikram PS case number 129 of 2012. According to the affidavit filed on behalf of the state, prima facie complicity of the appellant has been found, but, in this case, prosecution sanction has not been obtained for the appellant, having been given interim protection by this court. Para. We would hasten to observe that the aforesaid submissions on behalf of the state have only been taken note of without pronouncing on the merits thereof, and while leaving every aspect open for examination and consideration of the respective investigating agency, sanctioning authority, and the court at the appropriate stage and in an appropriate manner. These submissions have been referred to herein only in order to indicate that viewed from any angle, there does not appear any just and strong reason to restore the matter for reconsideration of the High Court. Para. In the totality of circumstances and in the larger interest of justice, we are clearly of the view that in this case, the investigation contemplated by the order impugned should be allowed to be taken to its logical end, but, while effacing the unwarranted and unnecessary observations of the High Court, lest there be any prejudice to any party only because of such observations. In other words, the entire matter is left open for examination by the investigating agency, by the sanctioning authority, and by the court concerned at the relevant stage and in accordance with law. Para. Accordingly, and in view of the above, this appeal fails and is, therefore, dismissed, but, with the observations foregoing, and while effacing the unwarranted and unnecessary observations of the High Court in the order impugned.